Big changes are hitting U.S. immigration policy right now, and they're not minor adjustments. We're talking about billions in new enforcement funding, tighter work permit rules, a major federal crackdown on border cases, and a court decision that could temporarily reshape the H1B visa process. Some of these updates could mean more opportunities, but others may bring stricter scrutiny, faster enforcement, and less flexibility for immigrants already in the system. In the next few minutes, we'll break down 3 to 4 of the most important immigration updates, explain what's actually changing, and most importantly, who is going to be affected. We'll start with a massive new funding package for immigration enforcement agencies. The U.S. House of Representatives has approved a massive funding package for immigration and customs enforcement, ending months of political conflict over the agency's future. On June 9, 2026, lawmakers voted to direct approximately $70 billion to the Department of Homeland Security. The measure passed by an extremely narrow margin of just 2 votes and was signed into law the following day, June 10. This vote brings an end to a 115-day dispute over ICE funding. The debate became so intense that it contributed to a partial federal government shutdown earlier this year. Much of the controversy centered on ICE enforcement operations and immigration raids, including actions that drew criticism in Minneapolis. After negotiations stalled, supporters of the funding package turned to the budget reconciliation process to overcome opposition and move the legislation forward. The final law provides enough funding to sustain ICE operations through 2029, effectively tripling the agency's annual funding levels. The bill includes $38 billion for hiring, training, paying, and equipping ICE officers, $22 billion for Customs and Border Protection personnel, $5 billion for border screening technology and AI systems, and $350 million for state and local law enforcement support. Impact on immigrants. This funding increase could result in more ICE officers, expanded enforcement operations, and greater use of technology to identify and process immigration violations. Immigrants with pending cases, expired status, or removal orders may face increased scrutiny as enforcement resources grow. The expanded funding is expected to strengthen immigration enforcement efforts nationwide through 2029. Move into proposed DHS work authorization restrictions. If you're a parole recipient, deferred action beneficiary, or someone facing removal proceedings, this update could directly affect your ability to work legally in the U.S. The DHS has proposed significant new restrictions on employment authorization, scheduled to take effect on August 4, 2026. Under the proposal, DHS will exercise greater discretion when reviewing work permit applications and renewals. Applicants may face heightened scrutiny if they have been arrested, charged, or convicted of a criminal offense, or if DHS believes they have ties to violent criminal activity, gangs, or terrorist organizations. For individuals who remain eligible, new requirements would apply. Applicants must demonstrate they are working for or actively seeking employment with an employer enrolled in E-Verify. They must also submit biometric information, complete identity verification procedures, and pass criminal background checks. Another major change involves validity periods. Employment authorization documents would generally be limited to a maximum of 1 year. Work authorization could also end immediately if DHS issues a final removal order or denies the underlying immigration benefit supporting that authorization. According to DHS, these changes are designed to create uniform eligibility standards, strengthen E-Verify compliance, standardize EAD renewals, and align employment authorization policies with broader immigration enforcement priorities. The proposed DHS rules would make it harder for many parole recipients and deferred action beneficiaries to obtain or renew work permits due to stricter eligibility checks and screening requirements. Work authorization would generally be limited to 1 year and tied to E-Verify employers, reducing job flexibility. For many immigrants, this could mean greater uncertainty, more frequent renewals, and an increased risk of losing the ability to work legally. A large-scale federal update on unaccompanied minors at the border. Since President Trump took office, DHS reports 146,000 of roughly 450,000 unaccompanied minors have been located. Nearly 300,000 remain unaccounted for, prompting joint ICE and HHS operations nationwide. DHS Secretary Markwayne Mullin praised enforcement and pledged to dismantle smuggling networks and hold perpetrators accountable. Acting Attorney General Todd Blanche says children were often abused, assaulted, and exploited by criminal sponsors tied to cartels. Federal prosecutors describe super sponsors using fraud, false IDs, and multiple custody claims. 3 Guatemalan nationals in Ohio were indicted for links to over a dozen smuggling cases. DOJ is tracking 15,500 super sponsor cases involving hundreds of thousands of minors from 2021 to 2024. Mullin alleges widespread abuse, claiming 600 to 700 reported assaults and 1/3 of girls victimized before border arrival. He blames prior Biden-era policy failures, citing unvetted sponsors and lack of post-placement welfare checks. He says many children are found in sanctuary cities, escalating federal-state conflict over immigration enforcement. White House border czar Tom Homan plans ICE surges into New York amid disputes with Governor Hochul. Hochul counters, arguing cooperation exists but federal actions risk violating residents' rights. Authorities vow aggressive pursuit of trafficking networks and recovery of remaining unaccompanied minors. And finally, a key court ruling that could temporarily reshape the H1B visa process. U.S. District Court, by order dated June 8, 2026, invalidated the $100,000 H1B visa fee, holding it was unlawfully imposed by the federal government. The policy originated in a September 19, 2025 executive order, justified as revenue for immigration agencies. Legal reasoning: the court found Congress must authorize changes to the H1B program. Because no congressional approval existed, the action violated separation of powers and the Immigration and Nationality Act. This decision conflicts with a late 2025 ruling that had upheld the fee, and follows challenges from multiple groups, including the Chamber of Commerce. Unless stayed on appeal, employers may briefly file new H-1B petitions for beneficiaries outside the United States without the $100,000 requirement. This is most relevant for CAP-exempt employers, selected CAP cases, and consular processing filings. However, the government is expected to seek emergency relief under INA Sections 212F and 215A. Even approved petitions may face consular delays due to limited visa appointments. Employers should treat this as time-sensitive, uncertain, and subject to rapid reversal. Employers should immediately review filings with counsel to assess eligibility and timing strategy in current window now. That's it for today's update. We covered key immigration changes, from enforcement funding to work permit rules and H-1B developments. These updates could impact many immigrants and employers across the U.S. If you found this video helpful, make sure to like, subscribe, and stay tuned for the next video.